Any other discussion from the commission? Seeing none, I'll take it out to public comment. Seeing none, I'll bring it back to the commission for a motion. Commissioner Rain.
Move to approve the committee's recommendation.
I'll second that.
Motion by Commissioner Rain, second by Commissioner Young. Any further discussion? Commissioner McNinch?
Thank you, Mr. Chairman. And, my first reaction when I read it was exactly that, I wasn't here for the committee meeting, but there just aren't a lot of people, especially here in the state of Nevada, that really do qualify for that, generally speaking. I mean, I guess there's going to be some exceptions, but my concern and degrees and stuff don't necessarily relate to being able to function at the level that I think people are anticipating on a commission. And I understand the concept of knowledge, and I'm not supportive of it for the purpose that I think it is too restrictive, and I just don't think that the intent of would ever be satisfied. I really don't.
Any further discussion? Seeing none, I'll call for the motion. All those in favor signify by saying aye.
Aye.
All those opposed, motion passed unanimous.
Kim Jolly for the record. So the next bill that the committee took up was SB 134. And I'll go right here. Senate Bill 134, and it's sponsored by Senators Goycochea, Gustafson, and Sagevsky, and then joint sponsors Ellison and Grady. And this is scheduled for a hearing in Senate Natural Resources Tuesday afternoon. This is kind of a long bill, so I'll let you kind of look at this summary first of all. An act relating to animals, defining the term water to include snow for the purpose of watering livestock, setting forth the meaning of point of diversion or place of diversion for the use of water for that purpose, requiring the Department of Wildlife to maintain certain fences, requiring the department to submit an application to the state engineer before placing a guzzler, and providing other matters properly relating thereto. Chair, how would you like to? Do you want to go through the language here?
Yes, please.
Okay, we'll just read it. So section 1, chapter 533 of NRS is hereby amending by adding thereto a new section to read as follows. For the purpose of watering livestock, the term water includes snow. In section 2, NRS 533.005 is hereby amended to read, as used in this chapter unless the context otherwise requires, the words and terms defined in NRS 533.007 to 533.023 inclusive, and section 1 of this act have the meanings ascribed to them in those sections. Section 3, NRS 533.475 is hereby amended to read as follows. The state engineer and the assistants of the state engineer shall have power to arrest any person violating any of the provisions of NRS 533.005 through 533.470 inclusive, and section 1 of this act, and to turn that person over to the sheriff or other competent police officer within the county immediately on delivering any such person so arrested into the custody of the sheriff, the state engineer, or assistant making such arrest shall immediately, in writing and upon oath, make a complaint before the justice of the peace against the person so arrested. Section 4, NRS 533.480 is hereby amended. Any person violating any of the provisions of NRS 533.005 to 533.475 inclusive, and section 1 of this act shall be guilty of a misdemeanor. Section 5, the use of water for watering livestock is hereby declared to be a beneficial use except as otherwise provided in NRS 533.495. And we'll go down to where the language is amended. And then We'll start right here. This subsection is not intended to apply that before April 1st, 1925, it was necessary to specify, prove, or determine the quantity of water in cubic feet per second, but is meant only to remove for the future any uncertainty that may have existed of such necessity. Number 3 is language being added on application to the state engineer for any such right, and in establishing any such right, point of diversion or place of diversion means a substantially specific and accurate description of the location of A, the place from which the water is physically diverted from its source, or B, the place at which the water is consumed by livestock, including, without limitation, the place at which the livestock consume water in situ and without the use of mechanical method of diverting the water. Section 6 is, and then section 7, if the department constructs or causes to be constructed a fence in carrying out its duties, the department shall, to the greatest extent practicable, ensure that the fence is constructed and maintained in such a manner as to prevent livestock from being trapped in the fence. Section 8, before placing a guzzler with a capacity of 1,000 gallons or more, the department shall submit an application to the state engineer. The application must include, without limitation, an accurate description of the proposed location and site upon which the department intends to place the guzzler and any other information required by the state engineer. Number 2, within 30 days after receiving an application for a proposed guzzler submitted pursuant to subsection 1, the state engineer shall approve or reject the application and notify the department in writing of his or her determination. Number 3, the state engineer shall reject the application if he or she determines that the proposed guzzler threatens to prove detrimental to the public interest. 4, the department shall not place a guzzler unless the state engineer has approved its proposed location and site. 5, as used in this section, guzzler means any artificial basin that collects or is designed and constructed to collect precipitation specifically for use by any wildlife. And that's the end of the bill. It says it would be effective for October 1st, 2013.
Thank you for going through that, and I wanted to have you go through that so everybody could see what we're dealing with on this one and why the discussion went the way it did.
All right, so from the committee, the recommendation from the committee was to oppose SB 134. Obviously, there were some concerns with turnaround on the applications to the state engineer within 30 days. There was discussion that the Department of Wildlife already has a catalog or database of the guzzlers in the state and keeps those in the Guzzler Atlas. They are responsible for going through, obviously, NEPA on projects on public lands. And there was some discussion that, work to improve the inspection and reporting provisions that are discussed in here could probably be done at the commission level through policy. So those were some of the discussions. Several of the committee members had discussions with the bill's primary sponsor, who indicated that they had some concerns with the way the language came out of legal, and they may be looking at an amendment anyway. So this is another one that may end up changing, but the general position of the committee was to oppose this bill as written.
Any other commission comment on this?
And just one question, the committee didn't discuss this, but I know there's some other language in here that may be cleanup, so maybe we need to define that our opposition is specific to the provisions that relate to NDOW and guzzlers. Am I reading that right?
That sounds correct. Yeah, we're confused too as well about this portion. Is that what you're talking about? The term water, including snow?
Right.
Having to do with some other, he's trying to do something else there that doesn't have to do with us. And then possibly this section as well. So, sure, if you want to state your position is relative to only the portions that affect the department.
Commissioner Morai?
Thank you, Mr. Chairman. From my understanding of the way this bill was presented, the way it came out was not as it was intended. It was intended more to address defense maintenance issues on the guzzlers. And so I'm not really comfortable with where we are, because from what I've heard is that they're supposed to come forth with an amendment. And so I won't be voting on the committee's recommendation this time.
And my understanding is the department's going to make a presentation that may clear up a lot of the questions that basically, the way I see it, this bill is asking questions that may have already been answered. We just need to make sure everybody knows where those questions are answered at. And I believe the bill sponsor and the Department of Wildlife and the Sportsman of the State of Nevada want the same thing, viable water projects for wildlife and fences that don't hang up livestock. And I think we all want that. We just need to work together and get there. So, Commissioner Drew.
Yeah, and just to address some of this, language on all these is going to be changing, and we are going to have a telephonic meeting in April to discuss legislative issues. So just because we take a position on a given bill today, with what's before us, doesn't prohibit us from changing that if we get some language changes that are favorable on any of this. So, we still have the option to do that in April if things change.
Commissioner McBeth.
With regard to limiting our comments to just things that pertain to the Department of Wildlife, what I see from this bill is an attempt to bring guzzlers into Nevada water law. Under current interpretations of Nevada water law, a guzzler which captures precipitation is not a diversion. And there's no water right. By changing the definitions of snow, and basically bringing a guzzler within the provisions of Chapter 533, then that would give the state engineer, powers to deny the use of a guzzler, as well as probably give anybody who files an application, would give anybody an opportunity to file a protest. And so what it's doing is, in my opinion, allowing people to stop us from putting guzzlers on public land. And so I think that's very dangerous. And so I think it goes much beyond just the specific provisions that deal with the Department of Wildlife on fences and whatnot.
Commissioner Drew.
And the only response I'd have to Commissioner McBeth's point is that if you look at the language under Section 1, and the reason I don't have as much concern with that is that it says, for the purposes of watering livestock, the term water includes snow. So I'm more than happy talking with the sponsor on this, as we're going to be, sounds like, interacting with them anyway and figuring out what exactly that provision is. I don't know if it addresses your concern on whether we want to speak to the whole bill or just the specific sections, but that's kind of what I was looking at.
Kim Jolly, for the record, also mentioned during testimony today was the letter from the state water engineer from 1982 that basically said that you didn't need a water right for a guzzler. So we have that document as well, and we can share it with the commission reps when they speak to them.
Any other commission comment? Commissioner Rain?
It's almost more of a question that it appeared by looking at the intent of the discussion of the matter that, like I say, the wording wasn't necessarily what was intended. The intent of the bill is not necessarily negative to wildlife. So how I vote on it's kind of, individual to the exact wording. Because it definitely sounds like the intent was not negative to the department, but the wording came out twisted.
Any other commission comment? Seeing none, I'll take it out to the public. Mr. Johnson.
For the record, Larry Johnson, Nevada Bighorns Unlimited. In addition to the July 23rd, 1982 letter from the state engineer in which he states the placement of guzzlers as watering sources for wildlife falls within the authority of NRS 533.367, and therefore it does not comply with the statutory requirements of appropriation of public waters under the provisions of NRS Chapter 533. I'd also like make sure the department utilizes in their presentation the interpretation of the Office of the Attorney General dated January 25th, 2011, which goes to the point addressed by Commissioner Drew about the meaning of livestock and snow. The intent of that bill was to require a water right for anything that hits the ground in precipitation, simply because that question was posed from the State Department of Agriculture to the Attorney General back in their discussions of should they have veto powers over in-dow guzzlers. And the Attorney General writes back, the practice of capturing precipitation from legitimate structures is not prohibited under current Nevada law. They go into further discussion in this letter that of the 345 large guzzlers and the 1,269 small guzzlers, that the amount of effective recharge to the groundwater is almost immeasurable. It's minuscule. Quite frankly, one warehouse intercepts more water than all the guzzlers. Roof on a warehouse or industrial building intercepts more water than does all the guzzlers combined in the state. One subdivision, one block of subdivision intercepts more water recharge than does all of the guzzlers in the state. Okay. We obviously oppose this bill. I think there are measures in place to upgrade fencing on old model guzzlers. I think the Northern Nevada Guzzler crew, the majority of their budget this year, is my understanding in conversations with them, is going to modernize, update the old style fencing to new pipe fences that we use now that prohibits either feral horse or domestic cattle to enter the guzzler drinker area. But at the same time, again, we have ample evidence that calves and go back and forth, fine, as well as wildlife. Again, I urge this commission to oppose this. It, as I testified in the committee, it did not come from a good intent to do right. It came from the Department of Agriculture originally to impair the guzzler program of the Department of Wildlife statewide. Thank you.
Any other public comment?
For the record, Brad Johnston, Lyon County Citizen Advisory Board. I made comments earlier to the Legislative Committee on this bill. We adopted a motion unanimously in opposition to SB 134. I would just urge the Commission to follow, to oppose the bill as well, because what we have before us is the bill as it's written. It may be amended in the future, but I think it's an important step in the legislative process that if it's before you this way, and it's unacceptable and you have opposition to it, voice the opposition, because that may lead to a better amendment and revised bill. Our reasons for our concern is how would this impact and impede water development? Most importantly, would things get hung up at the state engineer's office with permitting, whether the state engineer acts within 30 days or doesn't, protests, and so forth. And for that reason, I'd urge the commission to lodge its opposition to this bill. Thank you.
Thank you. Any other public comment? Seeing none, I'll bring it back to the commission. Anybody have a motion? Commissioner McNinch.
Okay, You know, and I do agree. Brad brings up a real good point, and I've seen it happen. You don't take action on something, you know, and your inaction could be misinterpreted, you know, as a form of support. So with that in mind, I would make a motion to accept the recommendation of the committee to oppose SB 134.
I'll second that.
We have a motion by Commissioner McNitch, second by Commissioner Young. Any further discussion? Seeing none, I'll call for the vote. All those in favor signify by saying aye. Aye. All those opposed?
Aye.
Commissioner Raines opposed,
Abstain.
and Commissioner Moore, I abstained.
Kim Jelly for the record. The last bill that the committee was able to review due to time was SB 213. Senate Bill 213, Senators Parks, Menendez, Spearman, Segerblum, and Woodhouse. And then also jointly sponsored by Assemblyman Carlton, Orenshaw, Martin, Munford, and Pierce. So the summary is revises certain provisions relating to the trapping of wild animals. And I'll just read this little summary for you first. An act relating to trapping requiring the registration of each trap, snare, poisoning device, or similar device used in the taking of wild animals, authorizing the removal or disturbance of a trap, snare, poisoning device, or similar device under certain circumstances, requiring the marking of a trap, snare, poisoning device, or similar device with a warning flag, increasing the frequency of required visits for a trap, snare, poisoning device, or similar device, providing a penalty, and providing other matters properly relating thereto. This bill has not been scheduled for a hearing yet. However, it will be scheduled in Senate Natural Resources. Okay. So the first section, Chapter 501 of NRS, they're adding trap means a device that is designed, built, or made to close upon or hold fast any portion of an animal. Section 2 is incorporating Section 1 of this act. Section 3, NRS 503.452 is hereby amended to read as follows. 1, each trap, snare, poisoning device, or similar device used in the trap taking of wild animals must be registered with the department before it is used. Each registered trap, snare, poisoning device, or similar device must bear a number assigned by the department or be permanently marked with the name and address of the owner or trapper using it. The registration of a trap, snare, poisoning device, or similar device is permanent. 2, a registration fee of $10 is payable only once by each person who registers a trap, snare, poisoning device, or similar device. The fee must be paid at the time the first trap, snare, poisoning device, or similar device is registered. Section 4, NRS 503.454 is hereby amended to read as follows. 1, every person who takes fur-bearing mammals by trap, snare, poisoning device, or similar device, or unprotected mammals by trapping or sells raw furs for profit shall procure a trapping license. 2, it is unlawful to remove or disturb the trap, snare, poisoning device, or similar device of any holder of a trapping license while the trap, snare, poisoning device, or similar device is being legally used by the holder on public land or on land where the holder has permission to trap, unless the trap, snare, poisoning device, or similar device creates an immediate and obvious risk of injury or death to any person, pet, or service animal. 3, every person who takes fur-bearing mammals or unprotected mammals by trap, snare, poisoning device, or similar device shall mark each trap, snare, poisoning device, or similar device he or she sets with a flag, which is clearly visible and of sufficient size to warn a person who is in close proximity to the trap, snare, poisoning device, or similar device of its location. 4, as used in this section, service animal has the meaning ascribed to it in NRS 426.097. Section 5, NRS 503.570 is hereby amended to read as follows. A person taking or causing to be taken animals by means of traps, snares, poisoning devices, or similar devices shall, if the traps, snares, poisoning devices, or similar devices are placed or set to take animals, visit or cause to be visited at least once each 24 hours, each trap, snare, poisoning device, or similar device during all of the time the trap, snare, poisoning device, or similar device is placed, set or used to take animals, and remove therefrom any animals caught therein. It's deleting the provisions of subsection 1 that would exempt the State Department of Agriculture or U.S. Department of Agriculture when acting in their official capacities. And then section 6 is incorporating the new sections upon passage and approval. Section, number 2 of section 6, section 3 of this act becomes effective upon passage and approval for the purposes of adopting regulations and performing any other preparatory administrative tasks that are necessary to carry out the provisions of this act and are on October 1st, 2013 for all other purposes.
Commissioner Drew?
Right, so the committee's recommendation was to oppose this bill as written. Most of the opposition, and we didn't have a lot of time to discuss this, but there were a lot of concerns in terms of the technical issues associated with the bill on many of the provisions. And one of the points that was brought up is, as written right now, it would be nearly impossible to enforce. One of the committee members wanted to stress that by opposing the bill, that we're not necessarily opposing some of the concerns that have been raised. And, you know, obviously the commission's had a trapping committee to start addressing some of those. And I think those were the key points that we covered in the short time we had to discuss this bill.
Commissioner Lane?
Mr. Chairman, I feel in some respects that I want to disagree with the committee. I understand some of the issues in terms of law enforcement, but I feel like the commission has only itself to blame. This issue came up in the 2011 legislature. The people who had concerns about this issue were told at this time that it would have to be the registration and the trap visitation would have to be brought. These were legislative issues that would have to be brought up at that time. The commission decided to take no steps with the trapping regulations. The trapping regulation committee decided to take no steps in this area. And I just think that if we're going to be opposed to this, we need to figure out some way to get the parties to sit down together and try to address some of these issues. This is not going to go away. This is a big concern in Southern Nevada with some of the issues that we've had there. And I think it's also a concern in Northern Nevada. So somehow or the other, we've got to deal with this issue. If we're unhappy with the way this is written, then we need to figure out how to resolve some of these issues.
Any other commission comment? Seeing none, I'll take it out to general public. Joel?
For the record, Joe Blakesley, Nevada Trappers Association. There are 4 points to this bill, and I'd like to address every one of them. We've got registration, we got visitation, we got flags, and we have tampering with traps. So why don't I start out with registration? I'll make a statement that we tried registration for 15 years, but what we tried was not trap registration. Think about that for a minute. If we're going to register a trap, we need to register a trap. What we did is we registered a person. You don't get a license plate that you put on every car that you own for the rest of your life. You get a license plate for a car. There's a mechanism for you to surrender that plate. When you sell your car, there's a mechanism to surrender that plate if that car gets stolen, et cetera, et cetera. If you're going to register traps, you need to create a separate number for every piece of equipment. Because there's no mechanism right now for the traps that I have sold. I have 300 of them out there with a number on it that I have no control over anymore. I have a number of traps that have been stolen. I have no control over that equipment. So are we going to register traps, or are we going to register people? What we did was tried for 15 years, and not one good thing came out of it. It's a flawed concept. The way that language is written right now is flawed. And, you know, I wish I could go back to LCB back in '77 or whenever that was. That's approximately when it happened. The legislature has heard this about 4 times, I believe, and as recently as last session. And it was rejected last session. It was a part of 226. So that's my main thing on registration. I don't think that a number like that can be used as a standalone piece of evidence. I mean, somebody that bought one of my traps or stole one or simply wanted to create a problem for me could take that trap, put that number on it, set it illegally, and take me out of the game if that was the case. Moving on, visitation. Visitation is simply a framework. The law does not say that you have to wait 96 hours to check your trap. That's not what it says. It says it has to happen within that time frame. The people that are opposed to the 96 hours always go to the worst case scenario. If I caught something that the minute I walked away from it, I wouldn't need a trap. I'd just sit there and shoot it. But if you think about it statistically, what is it? I'm not a statistician, but I'm guessing that it's probably somewhere between 4,000 and 10,000% more likely that you'll catch a trap in the last day of that 96 hours than it would be in the first day of that 96 hours, especially when you take into consideration the nocturnal habits of animals, the facts that animals don't necessarily, they will avoid a trap for a certain period of time after there's been human disturbance in the area. So you can take those factors and statistically, that's a problem. And the main thing is time and space. I mean, we have the same problems that the wardens have. I mean, you got to cover a lot of country. I mean, just the distances involved are huge. This 24-hour thing is nothing more than an outlying trapping. And that's what the effect would be. Flags. Okay. Look at that. It's clearly visible and of sufficient size to warn a person. Okay, is that 1 flag? Is that 20 flags? Is that 400 flags?
1 minute, Joel.
Okay, people can approach from a 360-degree direction. And the last thing is tampering. You know, I don't think any reasonable person would have a problem with somebody moving their dog out of the area if they saw a trap or releasing a dog. I don't understand why the general public would have any reason to do that. I mean, that's kind of an absurdity in my point of view. And I'll just finish by saying, is there anything that's good in this bill? I think not, and I would ask you guys to take a stand against it. Thank you.
Any other public comment? Mr. Yannick?
For the record, Gil Yannick, Carson Advisory Board. We had a very interesting discussion on this subject at our CAB meeting on Monday night, and I think a lot of what Joel said was brought up. We've had members of the public bring up the fact that this could be considered inhumane, but at the same time, we had some personal experiences describe the fact that with regards to a waiting period, any astute trapper is not going to let or the potential of letting a trapped animal remain in the trap for 96 hours. The value greatly diminishes if that animal expires and starts to decay. The value of the pelt is essentially worthless. So the discussion that was related to the members of the board was that most professional trappers will see to it that they're able to make the rounds of all the traps that they've set in way less than 24 hours, primarily because of the lost value. Why are they doing this if they're going to lose value? We've had comments, we've been told by a number of people who said they had animals caught in a trap. We've had members on our board say they've had animals that were caught in the trap, and they went over, released the trap, and the dog just went on its merry way. So I think the whole science of the trap itself has evolved over time. Not being an expert trapper, I can't sit here and tell you the changes that were made that made it grip the animal that's trapped without causing great bodily harm. But I'm saying that the issues that Joel brought up, the issues about some of the impractical things that they're asking in this particular bill, makes it one that our board is opposed to. Thank you.
Mr. Dixon.
For the record, Paul Dixon speaking on behalf of myself. Down in Las Vegas, Channel 3 News ran a segment here a few weeks ago on coyotes in our midst, meaning coyotes in town and bobcats and other things attacking animals. One of the reasons why we had SB 226 was public safety. And one of the concerns raised on the news program is that there have been more animals, we're talking hundreds of animals lost, presumably some of them visually seen being taken by coyotes or bobcats out of our city streets and housing belts in people's backyards. And they were concerned because, the local dog catcher or who we have, county who basically comes and manages things, or wildlife services, doesn't have the money to come monitor and remove coyotes out of neighborhoods. They just don't. We're strapped for money. We have more animals lost to having wildlife in our neighborhoods than we've ever had to an animal being trapped. We took extraordinary means, and I think that the part that kind of hit me solemnly was what the broadcaster is, what has changed in the last year that is driving animals into our town. And people don't realize that we live up against the wilderness in many areas, or we live in, as we expand our subdivisions out. And if we don't do what we do for when we do a sheep transplant and remove predatory animals from there, they're going to come in and be predatory within our subdivisions. And so I get worried when we start to put things up which further restricts what we're having here, when the real cause of loss of life and damage is the fact that we have wildlife in our neighborhoods now that we can't take care of, and that's destroying our people's pets. I think more people have lost pets just due to animals, wild animals, coyotes or bobcats being in our neighborhoods that have ever been trapped or hurt by anything. But we've took extraordinary measures to stop from getting an animal trap, but we're not taking extraordinary measures to keep the wild animals out of our communities. Thank you.
Bob?
For the record, Bob Bruner. These continue to get heard and rejected for the similar reasons. SB 226, which was the law that was heard last session, was designed to get trappers out of congested areas and get them away from population centers. Having a 24-hour trap check goes directly against that and brings all of the trapping into population centers, brings everybody in closer. You can't go as far away, you can't get out away from people if you've got a shorter trap check time like that. The registration, again, if they passed a law that said you have to put your social security number on the back of your car, just like your license plate, in addition to, all of us law-abiding citizens would do that, but when somebody robs a bank, they're going to just steal a car and they're not going to follow The registration came up again this last time because somebody illegally placed a trap in a city park, which is illegal, incorrect time, illegal, didn't have the license, they broke all the laws. They certainly weren't going to take the time to put their registration number on it. Okay, so it's, again, the intent is missed again with this trying to get it registered. The flags and getting them stolen, it's just, it doesn't help things out. And that's why these things keep coming up, and that's why they keep getting the next group that hears about this and gets educated about why these regulations don't work. Again, it'll get rejected, and we'll move on and do this again. So this is the way it's written. It doesn't get to the desired effect, and there really isn't a better way to get to that desired effect. It just has to, the regulations work the way they do, and you're going to have lawbreakers out there, and that's why we have a force to take care of that. But these don't fix the problems like finding out whose traps they are. You have to catch that person, and that's what you need to do, and registration will do that. Thanks.
Thank you. We'll take Doug first, and then Larry. Go ahead.
Brad Johnston, for the record, I'm speaking not on behalf of the Lyon County Citizen Advisory Board because we did not take up this bill at our meeting on Wednesday, but and I didn't intend to speak on this bill, but I'm struck by how broad some of the language is. It goes beyond mammals. It just goes to all animals and traps and that, and it brings me back to things that we have to do in our farming operations around our packing sheds for food safety issues in terms of setting traps and that. Are we then going to have to come and register those traps with the Department of Wildlife when we're not engaged in trapping in the manner that this is trying to address? But some of this language is so broad, it gives me pause as to what we would have to do around the 8,000 acres that we farm in Mason Valley, what we'd have to do around our storage sheds and packing sheds, and now we're going to be under the auspices of the Department of Wildlife in our farming operations. But some of this language is drafted so broadly, it gives me serious concern, and I would hope that the commission follows the committee recommendation in opposing this bill. Thank you.
Mr. Johnson?
Yes, I'm following my little brother Brad here. I also am speaking in opposition to SB 213, really for all of the reasons I think that have been testified. I think the 24-hour trap check is just counterproductive, bringing trappers closer into urban areas. The tampering and the flagging, completely unnecessary. The registration has been shown to have really no effect over the decade and a half that we've had that law in place. Can't help but smile at the suggestion of Commissioner Lane that we need to bring the parties together for more discussion. Quite frankly, this has been discussed between those same parties for over 30 years. In every legislative session, there are anti-trapping bills. It's not a matter of solving issues. It's a matter that anti-trapping factions want trappers to go away. That's really the bottom line with all of this. Thank you.
Any other public comment? Mr. Volz?
Yes, for the record, Fred Volz. I would like to speak very much in support of this legislation. It is horribly overdue. When we have a car that's stolen, the obligation of the owner, once they realize the car is stolen, is to report it to the licensing authority. It should be no different with traps. Recently, December 2012, here in Washoe County at Thomas Creek, the wildlife game warden and his staff spent 130 hours staking out illegally placed traps. Nobody showed. It would have been much easier had those traps been registered. The costs for the traps need to be borne by the trappers who are placing them. So if there's a cost to doing that and a system that has to be set up, so be it. It's a lethal weapon, It needs to be controlled. The second point, the 24 hours. It is totally ridiculous to suggest that you should have an animal trapped up to 96 hours in a trap. Looking at a trap from a distance and not physically inspecting it is really not satisfactory. Point 3, the public needs the ability, which it does not legally have presently, to tamper with the trap if it poses a danger. If trappers are responsible and they're inspecting their traps on a regular basis, they should know if something has been done imprudently. Also, when we have laws, there isn't a policeman standing over every one of us to enforce them. So to suggest that there aren't the resources to enforce any type of regulation is really ridiculous. And finally, marking that trap is essential because usually they are buried and hidden and not always visible to the public. And we had that problem with the Spring Mountain area and the 2 million people plus who use that each year. So again, I would strongly recommend that the Commission support this legislation. It's sound public policy and it's a public safety issue. Thank you.
Ken?
For the record, Ken Joy, Nevada Bighorns Unlimited. Trapping is one of the most effective methods to manage wildlife, bobcat, coyote, so forth. My concern is what is good for wildlife. Is this what has been proposed going to benefit them? In my opinion, it is not. A couple of meetings ago, you all sat here and heard Bob Bruner speak about the effects of such predators in the Sheldon Wildlife Area and how that relates to the areas that immediately border it. You cannot trap or manage any of these predators on the Sheldon like you can the areas that surround it. And the fawn success rate is significantly higher outside of the Sheldon than it is on it. So, is it good biology to bring 70 trappers into one location surrounding town, yet leave those areas outlying? They can't be reached within the 24-hour trap check. Void. Personally, I don't think it is. It's not good for any of the animals that they're after, or like in the Sheldon case, the antelope. So that being said, please oppose this bill. Thank you.
Thank you. Any other public comment? Seeing none, I'll bring it back to the commission for possible action. Ms. Lane?
Mr. Chairman, I would just say in terms of the law enforcement issue, and I noticed that there was a discussion at the legislative portion this morning talking about that this would be impossible for law enforcement. But I would point out that the 96-hour trap visitation violation is probably one of the most, or the biggest citation that's issued, and that was on the NDOW website. So clearly, there's an issue with this in terms of law enforcement, and I also think if you have to have surveillance of traps because you can't identify who set those traps, that's another problem. I just think that before we dismiss this legislation out of hand, that we at least talk about the fact that there is a need to look at some of these issues. Thank you.
Thank you. Commissioner Rain?
Well, Mr. Chairman, just briefly, if you love your sage grouse and your dogs and your cats, hug a trapper today. Therefore, I would like to move to support the committee's recommendation.
Commissioner Wallace?
Second.
Okay. Yeah. Commissioner McNitch?
Thank you, Mr. Chairman. I'm inclined to support the motion from the standpoint that I think that there are some issues with how the legislation is written, and similar to the previous bill, where if it's going to be something that goes through, I personally believe that there needs to be some changes to it. I've expressed my concerns in the past with the 96 hours. I've expressed those to Joel. But I can tell you that 24 hours just seems unrealistic to me. That's why I think part of the discussion is important, is to get it all out on the table. We've kind of skirted it, but we've never really had those in-depth discussions, not in my mind. I do have a very serious concern with just the general public disturbing any traps. I understand the public safety issue, but the public's not going to understand. Number one, we're leaving it up to them to make interpretations of the law. I think that's really bad precedent for any law to set, for anybody to just make those interpretations or allow the public just to make them. It would be based completely on perceptions, and I do believe that warrants, that basically makes it very unenforceable. If people's perceptions that it's a public safety issue, they just remove a trap. They're not trained to deal with poisons. I think we could be creating a bigger issue with people handling poisons if that's what's being used. But having said that, I do believe that there are, it's worthy of the discussion. We in the time that I've been around the commission, we've hit bits and pieces of it here and there, but we've really never had those discussions. And it'd be beneficial to me and Joel. I know you guys, I get it, been through it a million times, but I think it is worthy of those conversations. The registration, it's complex. Illegal trappers, like the ones up in Thomas Creek, unless they never catch the smart ones, why would you use a trap with a registration on it? So that kind of stuff we're not going to alleviate by having registration. We're not going to catch the guys that are illegal trapping. They're not going to use something with a registration or identification mark on there unless it's Joel's. So some of those issues are gonna persist regardless of what's done. Some people are just bad, and I don't think we can legislate that out. So I'll support the motion, but I do think it's worth some discussions. And SB 226 largely came out the way that it did because it was there was an effort made last minute to put it where it was. Otherwise, that bill was largely headed to something like this, I imagine. So it just depends on the temperature of the legislature and how the sides are all stacked up, and I think we got to be cognizant of that a little bit. So those are my thoughts.
Commissioner Drew?
I'll just state that I'm comfortable with the motion simply because I think the technical issues in the draft we have before us are just too big to overcome, and I'm not sure how to address it other than that. If we get a new version and some things come out, again, we have every right to take a look at the new version and go from there. But this version to me just has a lot of technical issues associated with it.
Any other commission comments? Seeing none, I'll call for the vote. All those in favor signify by saying aye. Aye. All those opposed?
Opposed?
Motion passed 8-1.
And Mr. Chairman, before we move off of this particular one, with my comments in mind, I'm hoping that we do something as a commission to, this isn't a good place to be reactionary. That's just my personal opinion. We don't meet often enough to keep up with the pace of the legislature. There are some where we're not going to want to be neutral in one way or the other. And this is one where, regardless of where it might get stuck or might end up ultimately, as it works its way through the system, the commission, now that it's been brought forward, should take a little more active role on this one. I personally believe that's just my opinion, my personal thought.
Okay. That's all the items that the committee was able to get to, but we do have more items that they weren't able to get to that I think are important to discuss as a commission. With that being said, though, it is noon straight up. We're at a good breaking point. Let's take lunch for an hour, come back straight up 1 o'clock. We'll get going again and continue this discussion on agenda item number 9.